Sup. How we doing? Got to go back at it one more time, one more again. Got to get into this. We're going to make sure this is clear. How y'all doing? Everybody all right? You know what time it is. Got to work from the giddy up. Got to use this. You know what I'm saying? So, what we're going to get into today is what you would call I know it's backwards. It's U.S. Code 42. All right? Subsection 1983, civil actions for deprivation of a right. Or it says rights when it means your rights or privilege. Let's begin. It says every person who under the color of any status, ordinance, regulations, customs, or usage of any state of the territory or the District of Columbia, subject or cause to be subject, any citizen of the United States or other person within the jurisdiction thereof to be deprivation of any rights, privileges, immunities secured by the Constitution and laws shall be liable to the party injured in the actions of lawsuit, in equity, or other property or proper proceedings for redress. And then it says, except for that of any actions brought against a judicial officer for an act or omission taken in such officer's judicial capacity. Injunctive relief shall not be granted unless a declaration decree was. Basically, what it's saying is like you can't go after a judge or a judicial officer unless they violate their canons. So you got to hold them accountable. Oh, they got my man Clark Pena. All right, now I see you, Clark. I see you. You got to hold them accountable to their canons. You got to make sure they step out of their canons under canons law. See, the lawyers got the judicial code of conduct. The lawyers, New York State Code of Professional and Responsibilities for lawyers. The judges have the same code of professionalism and responsibility for judges. These are their canons. So you got to catch them when they come out of their canons. That's for them. But we're going to go to the fact of these other individuals on this law. So we're going to go to the beginning where old boy used this car. He ain't going to go old boy. When the director, assistant deputy director of North Brooklyn Health Network used his car in threatening manner, he used it in 3 separate incidents against 3 separate officers on 3 separate occasions. But we're going to talk about my occasion. When he did so, okay, fine, that was that date, boom, got you with all the laws that he violated from 19500, which is official misconduct as a public servant. Then it goes on to the traffic laws, which is 1212, reckless driving. He's going to try to say that, oh, my foot slipped. So your foot slipped? Yeah. So it slipped on 3 different separate occasions. Your actions was intentional, plain and simple. We're going to move on from that fact because I gave you all of that information. You can go into other videos and see it. We're going to move to the fact of how did it get to the point of what you would say is the whistleblower. Now, the key thing is when he first did it, right, in breaking the law, also in violation of this corporate compliance policy, I see Randy Klein done joined in too, where he violated his corporate compliance policy based on the fact, all right, that he was on probation. Okay? He was hired in April. You're on probation for a whole year. You did this in July. Okay, so now we're going to look at that under the employer's rules and regulations of 5.2.3. Your actions would constitute gross misconduct. He was supposed to have been terminated. But somebody shined a little star and gave you a little pass. No problem. You forget what we do. I guess you look at us hospital police like we're all dummies. No, we're not. And you're subject to the same rules and regulations. I don't care if you came from NYPD. You're still subject to the same rules and regulations. So your actions, we're going to get you on your actions. We're not going to get you on any hearsay. It's going to all be in your actions. So moving forward, we're going to go to the fact of after you did the incident with your vehicle and did the unlawful integration, while I was off the clock. We're going to go back to the fact of my return to duty. So when I returned, you had the gate officer and you had the parking attendant tell me, you told them not to let me in the park for where I paid for parking. Undersigned contract agreement. Okay? So as I'm there swiping my ID to get in, here comes I buzz the parking attendant, and he comes downstairs and he says, smiling, your boss says for you to go park. What's up, babe? I'll give you that wave. He says to go park. All right, clock. He says to go park in the visitors parking lot or park on the street. Violation of your corporate compliance policy under harassment, violation by a breach of signed contract agreement. You have no right to do that. You're an employee. You're not a guard. You're an employee. Get that in your head. A lot of these people get this in his head like, I'm the director. I can do what I want. Is your name on the side of the building? I don't believe so. It's the city of New York. Were we on city of New York grounds? Yes, we were. So you follow the city of New York policies and procedures. Okay? You don't bring in no stuff from wherever you came from or whatever you thought was in that movie running in your head. It doesn't go down like that. So, in his actions in denying me access back to my parking where I had to go and park somewhere else, causing me to be late, that kicked in the whistleblower right there. See, because by first action and then the second action would bring about retaliation. There it is. What is the first action? The action when he broke a law, rule, regulation, or law. It's in the corporate compliance policy. So once he broke the rule, regulation, or law, that's the first part. All you got to do is report it, which was done. It was reported to both the captains. Now the second part kicks in when you retaliated. And retaliation, that's also in your corporate compliance policy. So the action of retaliation kicked in that whistleblower. And as a civil servant, it kicks in Civil Service Law Section 75B. Right there. Because once you report them, they can't take no adverse actions against you. So when they do, hey, it's going to be used against them. All right? Because of the simple fact, they took the adverse action. And they did. Now, the key fact that it kicked in the whistleblower, it also kicked in U.S. Code 42. Why? Because you deprived me of a right or privilege. Why? Because I paid for this. You have no right to it. There's a signed contract agreement and it's on the record. So I paid for this just like anybody else. But since you wanted to come at me on a personal level, I got to get this guy. You don't even know this guy. You just got there. But I got to get this guy. Not a problem. Not a problem whatsoever. Not a problem at all. Your mere actions and what you do shall dictate what's supposed to happen to you. But yet it's still, you had the juice. So they basically look the other way. Yet it's still, when you go and you file a complaint, it also states if you're going to file an EEO, you have basically 45 days. Unless it's ongoing, in which in your case, It was ongoing every month, every other month. So we got the actions of you denying my access to my parking from July to partially a good portion of August. But it wasn't until the other incident, oh, what do you say about me with my uniform jacket? When you start talking trash, you wanted the captains to write me up. Beautiful thing. Beautiful thing. Captain Bottoms says, I want to go to Parks. Not a problem, Cap. So we got off that morning. Me, her, and Officer Johnson went to Parks. And as they buying that stuff, I bought a complete uniform. Because I had the funding at the time. I had the funding. And the key thing was, she was like, get a jacket. I got a jacket. You breathing on her back because of the jacket. And the jacket was inside my locker. And he's trying to talk. You're trying to talk trash to her. And she says, the jacket's in his locker. But let's just get back to you're depriving me of my right and my privilege of parking in the paid parking lot for the employees, for which I was parking 2 years and a month before you even got there. I stopped parking there in March 2006. You wasn't hired until April 2008. We're going to go up now from that Jackie Roberts. I love calling it Jackie Roberts. We're going to go up from that, and we're going to move forward to the fact that it was reported in the fall to the EEO, the facilities representing EEO, who was obligated, once they got the report, she was supposed to forward that information to the corporate compliance officer. And once she forwards it to the facilities corporate compliance officer, that officer is supposed to take it and forward it to DOI, Department of Investigations. Because laws were broken, it was supposed to be forward. But yet and still, you know what they do. We're going to take this and flush this. We're going to wipe our behinds with it. Not a problem. It's already on the record. Now, because I came to the EEO or went to the EEO and filed a complaint, you retaliated. You got my tour commander to get those time and attendance together. The ones that you caused. And bring me up on charges for it. So that would be fraudulent charges, right? So you basically had them submit instrument on a record with false written statement, punishable instruments on the record with false written statement. 21045, right? Class A misdemeanor. Filed it on the record to be used as an accusatory instrument going to 40 Rector, right? Yeah, because I'm going to get you for your job. You notice I let you I didn't pull out none of the laws that let you run your course. You're going to do that, right? Yeah, that would be 175.30. Or for instance, for filing a false written statement. Each other one that you filed after that, 175.35. Class E felony. Each individual that participated, 195.100. Official misconduct by each individual that participated. You all work for the corporation, 2020. Subsection 2020. Criminal liability of the corporation. You're employees of the corporation, subsection 2025. Criminal liability of the corporation. Okay. You filed it and sent it to another organization, another governmental organization, such as 40 Rector. You would use it there. That would be 496.02, corrupting the government. Yeah, because you're using the facility. You're using the magic from the employer to go from one to the next. Yeah, that would be corrupting the government. So, with all of that, it still boils down to that U.S. Code 42, which is a federal law, which trumps all your local and state laws. Even though the whistleblowers kicked in for your actions, it would be Civil Service Law Section 75B under the Whistleblowers Protection. It would be New York Labor Law number 740 under Whistleblowers Protection. And then New York City Local Law number 33 under Whistleblower Protection. But yet, this is where your union come in. Right, Randy Klein? In representation. that dog, that Todd, that grievance coordinator who's supposed to be a litigations attorney. First, you got to find out what these guys do in the whole 9 yards to be the grievance coordinator in the whole 9 yards. And then the fact that you have to go to school for law to be that litigations attorney who does the collective bargaining for our job position on the signed contract for civil servants. So we're going to move forward with this as ye known or reason to believe have known. Or known or reasons to, or known or should have known, not to violate your corporate compliance policy, not to violate your canons under that signed contract agreement in representation for us or for me as a constituent of that union. But you turned your head. Not a problem. Not a problem. We're going to go back to the EEO. All right. So based on the fact that this information was filed, the EEO, who basically looked the other way, allowed them to continue with their nonsense. So they, each one of these documents that I have, that you keep sending me, oh, you're going upstairs to labor relations for this and that. These accusatory instruments that you have filed on the record. Remember after that first one you filed on the record? Class A misdemeanor. Subsection 175.30. Each one that you filed on the record that came afterwards, basically harassment, but yet and still will also constitute, because it's an accusatory instrument, you forced me to go through this. You don't even pay attention to what you're putting people through under mental anguish. But each one you filed, that constitutes 175.30. Those are Class E felonies. This is the reason why the union had to take and do whatever with the employer and make it wash away so fast, because they knew that he was negligent in his actions, and then the fact was, we're just gonna make this guy disappear. How many people have you done that to? That's the first thing. That's the key. Now we're gonna go further with this. We also gonna go to the fact that after being forced to go to these hearings, and I'm telling them that an EEO is in place, and the facilities, how would you say, labor relations specialists, once she was informed when I got upstairs with the union president, she refused to acknowledge it. All you had to do was take 1 minute, pick up the phone, call downstairs to EEO. Did he come in your office and file a complaint? Yes, he did. What is it in reference to? This, and that. When was that about? Blah, blah, blah. Okay, thank you. Hang up. We're going to put this on standby. You don't even got to cancel it out. We're going to put this on standby because for some reason, these things, there's something kind of fishy here. Remember, as a labor relations, you're supposed to represent all employees, not just the ones you feel are, this is my buddy. This is my buddy. Your buddy got you jammed up in a position where you could get terminated for violation of Mayor Order number 16. Your buddy got you in a situation where you possibly face jail time. Oh, it's been so long since your buddy continued this up until 2006. I mean, let's get this right. 2016. He was still doing this. So if a felony could stay on the record for basically 5 to 6 years, where they could come back after you for that felony. Figure it out. They could get all of those felonies and go all the way back to number 1. I think I'm number 1, but there were other people, so. But like I said, how many people did you deprive them of a right or privilege? The mere fact that you went to 40 Rector, you did deprive me of Civil Service Law Section 75B, right? You did deprive me of the whistleblower. Just depriving me of the whistleblower, that's 3. That's 3. Here's the sweetness. I want you to Google U.S. Code 42 and look at the fact that there's no statute of limitations on it. So it's still open. It's still open. This is comical, man. This is truly comical. How people that's supposed to be representing you in the whole 9 yards allow this to happen. And then also how these people come into a work environment with these bully attitudes. I was such and such. I learned I went to John Jay for graduation and spoke to an officer there. And they said that Todd came from the Board of Ed. So if you was at the Board of Ed, how did you get to Teamsters? What did you do? What did you screw up somewhere or something like that? Peace and blessings, Randy Klein. Peace and blessings. All right. I'm just trying to wonder. Like I said, with all the officers that was done, look, man, I got this guy's stuff right here. You know, I got his whole folder right here. I think I'm playing the stuff that you guys did and allow these guys to do when people are filing complaints in the whole 9 yards, and you think there's the statutory limit and ran past. No, it hasn't. Once they filed a complaint in the whole 9 yards, it was just that you was deceptive in your practices in the whole 9 yards, and you need to be held accountable. Period. The good thing about it is you can bring in or file a complaint with the PIB, Public Integrities Bureau, in the whole 9 yards. And then they also say if you wanted to go further, you know, you got to seek counsel on your own to basically seek lawsuit against these individuals in the whole 9 yards. Oh yeah, it is achievable. You know, you got to do your homework, see, because you got these individuals who's telling you, oh no, it's too late. I remember Clark hooked me up with some lawyer. And the lawyer was like, oh, it's been 2 years. There's nothing you can do. There's nothing you do. Immediately. He didn't even want to hear the case. When they don't want to hear your case totally, they're in bed with them. I'm not saying Clark was in bed with them. I'm just saying the lawyer that he sent to me, and you know, he said, yo, I heard about your case. Your case is pretty ugly. It's in violation of Taylor laws in the whole 9 yards. Yeah, this is a violation of Taylor laws, but it's also in violation of business law. It's also in violation of penal law. Okay? It's also a violation of their own corporate compliance policies. You know, wherein Executive Order number 6312 gets in. 6312, wherein that brings in the State Attorney General office. And what is that? 349, subsection 349, under deceptive practices, that also brings in the State Attorney General office in reference to how they did this, not just to me, but to a number of people. See, they was letting him run amok. I don't know if it was because of the recession that was of 2008 on, where they got a green light, we could get rid of people. You know who was in charge then. And he just let these people run amok. I don't know if it was that or if it was something else. But this idiot was really running crazy. You know, it's really, really, really running crazy. So, on that note, you know, I'm just going to still do my homework. My boy hit me with something the other day. He said something about if something can be destroyed by the truth, then it needs to be destroyed. I know you're like, well, why are you saying that? Because he's gone. Yeah, he's gone. But there's such thing called redress, remedy. Where the hell is my remedy? That's the key. You know of this. You're responsible for this. You must be held accountable for this. And like I said, that Jackie Robinson. Ooh. U.S. Code 42. Matter of fact, the jersey I'm wearing, it's got that number 42 on the back, baby. Oh, boy. So on that note, you know the deal. The facts cannot be altered nor denied. Though it's getting beautiful outside right now. It's kind of hot. I'm about to cut the AC back on and do whatever, do what I do. Research. You know what I'm saying? Research. Shout out to, what's this guy? Freddie. Shout out to Officer Freddie. He hollered at me. He said, yo, can you open this up for me? And yeah. I'm not an attorney, but I'm doing a damn good job. On that note, you guys take it easy, all right? Have a wonderful day. Later.